already. A slightly unusual start to this morning's session as we are coming to you from the International Dispute Resolution Centre, the IDRC in London. So that's why the room was open before we kicked off this morning. So some of the participants are already here. So good morning and welcome back to this first episode of ConstructionCast for 2022. It's lovely to have so many of you back with us, and big welcome to anyone who's joining us for the first time this morning. As I said, the setup's slightly different this morning. The IDRC have kindly allowed us to use their facilities in London. So we are going to be hosting this session in person, myself and Paul here in London, and virtually with Fatima and William, who I will introduce to you all in just a moment. So if you do want to know more about the IDRC, I'm sure one of my colleagues is going to put a little link in the chat box in a moment. And if you want to know about their hearing facilities and the kind of things that you can do in the centre, because they've got fantastic facilities for virtual, in-person and hybrid hearings, just get in touch with us or follow the link and we'll put you in touch with someone who can tell you a little bit more about that. So joining me this morning in London, we have Paul Sills. Paul is an independent arbitrator, mediator based in London, working with Arbitrage International. Paul previously spent 26 years as a barrister, and before that he had a successful career as a navigator in the Royal New Zealand Air Force. He also spent 2 years as the CEO of an international super yacht construction business, so he's had quite a varied career. He's won a number of awards, including 2020 Mediator of the Year Award in the annual New Zealand Law Awards and the Prime Disputes Leadership Award for Equality and Diversity in Dispute Resolution. In 2021, he was nominated as one of the most influential lawyers, 25 most influential lawyers in New Zealand. So great to have you here in London with me, Paul. Thank you for joining us.
Thank you.
Joining us from Dubai is Fatima Balfaqi. Sorry, Fatima, I've said that wrong, haven't I?
Balfaqi.
Sorry. Legal counsel, independent arbitrator, mediator and business consultant. Fatima has spent 16 years working on a wide array of commercial, legal and operational matters related to different sectors, including dispute resolution in construction, government enforcement of contracts and procurement for government entities. She established her own company, RKAH, in 2018. As a UAE national, she has an active involvement in the ICC UAE and is a member of the UAE branch committee, a board member on the MENA advisory panel of RICS, and is also vice chair of CIARB's UAE branch. And finally, joining us from Scotland, we have William Frame Bell, a chartered arbitrator with extensive experience in corporate and commercial international arbitration. His particular focus is on construction-related disputes in the Middle East and has a good working knowledge of the UAE Civil Code. Interestingly, when I was looking for something to say about William, I found in his biography, it says that he has sailed across the Atlantic Ocean and also holds a Motorsports UK International Cross-Country Rally Licence. So it's always quite fun when you find something a little bit different in someone's biography.
Good morning. That's very
good morning. So this morning we're going to look at international arbitration. The last time we looked at this topic was back in April 2020, right at the start of the pandemic, when we all kind of thought we'd be working from home for a few weeks and we might be back to work in the summer. And 2 years later, we're still here kind of in this hybrid virtual format, but you know, this might be the way things have come. In that session, I went and had a look back to see what we were talking about. We were looking at virtual hearings and how they might work, having not done any of them. And we had some great tips in that session for preparing for arbitration. So if arbitration, obviously you're here this morning, it's something of interest, you can head over to the blog or the YouTube page and rewatch any of our past sessions, including that one. So 2 years on, we're taking another look at international arbitration, seeing where we've got to, what has changed and what might be in store in the future. As always, pop your comments in the chat box and I'll try and ask the speakers any questions as we go along. So William, we're going to come to you first this morning. Starting with arbitration process and why is it so well suited to resolving construction disputes? And we've got you on mute.
That's not a very good start at all. Good morning, everybody, and I apologise for that. The key thing in the international sphere of construction that arbitration gives is it gives parties, counterparties, often from various different countries, the chance or the opportunity to resolve their disputes in a country of their choosing under rules of their choosing. Many large-scale industrial engineering, infrastructure and development projects take place in countries where, unfortunately, we have to accept the fact that the local legal systems are not necessarily geared up or indeed for arbitration or pro-arbitration. So what arbitration does is it enables parties to effectively choose where the disputes are going to be dealt with, and in large-scale infrastructure and engineering contracts, there are often disputes. So it's a very, very important thing for the parties to get right at the very start. Arbitration offers flexibility to parties. You can choose your tribunal to an extent, you can choose your experts, you can choose your procedures, and the flexibility that the process of arbitration offers parties enables them to design, if you like, a dispute resolution process to suit them in a place of their choosing that does not have to be concerned with enforcement issues, or at least can control enforcement issues, or the rules of the local courts in whichever countries are related to the actual project. So really, it's a, dare I say it, if I could say it, it's a no-brainer for construction disputes arbitration.
Thanks, William. Fatima, Dubai is quite a popular choice, but at the end of last year, towards the end of last year, we saw some big changes at the DIAC and DIFC-LCIA. Can you explain for those not in the region, or perhaps those of us who are not so familiar, what's happened and why it's so significant?
Yes, first of all, thank you very much for having me with you today. I'm very excited to share the stage, so to speak, the virtual stage with our esteemed panelists. First of all, for those who are unaware about Decree 34, it goes by Decree 34 here. It needs no further introductions. It is a decree that was issued in September, on the 20th of September last year, where it dissolved multiple arbitration institutions here in Dubai, where it dissolved the DIFC-LCIA Arbitration Center, in addition to Emirates Maritime Arbitration Center in Dubai. And it moved all of its property staff cases to Dubai International Arbitration Center. Dubai International Arbitration Center, or as it's called, DIAC, it is a mainland arbitration center. It now should have 2 offices, one in Dubai mainland and one in DIFC as a branch. Basically, they have their own set of rules. As per this decree, again, and a part of its growing pains, so to speak, is that we have some existing cases with the DIFC-LCIA and Dubai Maritime as well, that were already in full swing before this decree was issued. So the instructions now is that these will carry on being applied, and the rules of the appointing authority at the time, which is the DIFC-LCIA or Dubai Maritime, will still apply. But anything beyond the point of the 20th of September, if parties wish to apply an arbitration through the DIFC-LCIA or Dubai Maritime, they need to contact DIAC, and DIAC's rules are going to apply as well. So this is quite a significant decision that happened in Dubai, and it came with a lot of mixed reactions, I would say. But one cannot discredit or oversight the strategic look when it comes to combining arbitration centers and having a more focused approach to kind of fortify the position that Dubai has in the arbitration scene as a seat of international arbitration. It have been ranked multiple times within the first 10 international global seats at this point. So we are still in the phase of, I would say, the growing pains. We are waiting yet to see an official plan from DIAC, which I believe will come soon, to kind of map out the way forward. But we are highly optimistic and very supportive of whichever direction this will take.
William, if you have got a contract that references the DIFC-LCIA rules, do you need to panic? What should your next steps be? No,
so there's absolutely no need to panic. And as Fatima has very, very well set out, that cases that were arbitration cases that were live, so to speak, before September of last year will continue. And anybody who has a DIFC-LCIA arbitration clause in their contract that hasn't yet been utilized, then as Fatima has said, that the arbitration effectively will now be administered by DIAC, which is the Dubai International Arbitration Center. Now, DIAC is a first-class center in its own right, is very well known throughout the Middle East, particularly obviously in Dubai, and has handled some of the largest construction disputes in the Emirate over the last sort of 10, 15 years. So it's no stranger to construction disputes. So there is no need to panic. And albeit the change was made very suddenly, effectively overnight, parties should not be concerned. They will still be able to have their disputes administered properly, and they can still obviously choose their arbitrators. Now, of course, if parties don't want their cases referred for whatever reason to DIAC, they are at liberty on a joint basis to change the terms of any arbitration agreement, which is always the case within arbitration. It's a consensual process. So if parties themselves want to change their dispute resolution clause, then they can do that. So there's absolutely no need to panic. And as Fatima says, DIAC is a world-class institution in its own right. And I'm quite convinced that over the next decade or so, Dubai will become, if not one of the most effective arbitration centres in the region.
Thanks, William. So, Paul, we've mentioned there that one of the benefits of arbitration, and perhaps if you have got DIFC in your contract, you can choose a different arbitrator there. What is it you need to think about when you're choosing an arbitration centre? What's important? Why does it matter where you pick?
Well, it's a good question, and as William touched on in his first answer, one of the benefits of arbitration is you have a choice, and your first two key choices are where you will have your arbitration, what we refer to as the seat, and that's important because that legal system will look after the procedural aspects of your arbitration. And then the second big choice is what institution. Will I have institutional rules or will we not? And different considerations for both. So briefly, why parties would typically choose a seat. William touched upon it in terms of the sophistication of the legal system. So reputation and recognition of the seat, the place where you might have your arbitration is sort of first and foremost. The formal legal infrastructure of that seat, what we call the rule of law, how neutral and impartial the legal system within that country is seen, what the national arbitration market is like. Is it a model law arbitration regime? And then last and but no means least, sort of the track record of that jurisdiction for enforcing both agreements to arbitrate and arbitral awards. So those are the sort of the typical checklist. What we've seen over the last couple of years is an increasing interest also by parties on the approach of particular jurisdictions to virtual hearings and their approach to the administration and support of that data protection and things. So there are other aspects sort of coming into that question. And then when it comes to institution, similar considerations and really sort of the institutions of choice are there because they're recognized as being the institutions of choice, ICC, LCIA, CIAC, Dubai, Abu Dhabi Arbitration Center, Hong Kong, Shanghai, etc. The list can go on and on. And again, the key choice there is reputation followed up by previous experiences. So if you've had a positive experience using that institution, and you've got a lot of choice. There's on the last Queen Mary survey, there were over 90 plus seats or jurisdictions for arbitration being considered, and there were over 50 institutions. So there is a lot of choice. Some reasons why you might go out of the main grouping. It might be a fee-driven thing. It might be an approach to a perception of flexibility of the rules. Some parties, about 35% of international arbitration, still pick ad hoc arbitration, i.e. they don't have an institution governing the process because they see that as more flexible. They see that as being better for party autonomy. And again, data protection, ability to host and support virtual hearings. These are all aspects that are coming into what is really quite a wide set of options to choose an institution or an arbitration centre.
Thank you. Fatima, do we think with the changes in Dubai, so when we last held a session like this, one of the speakers mentioned that 26% of all arbitrations worldwide were held in Dubai. Do you think these changes could be an opportunity for other arbitration seats such as ADGM or ICC to step in and take some of Dubai's market share, or do we think it will still continue to be popular?
Yes, again, I think there is a very big opportunity for the rest of the Emirates in the UAE to kind of step up and share the stage, so to speak, with the Dubai as an arbitration seat. And we see like very big steps happening in Abu Dhabi with the first establishment of Abu Dhabi Global Market, ADGM, as in a similar fashion to DIFC. And now having the ICC opening the regional office in Abu Dhabi as well, which is attracting a lot of cases there and getting very good feedback as well from the market and from the region as a whole, and for the ICC to kind of reach out for the market a little bit more. In Abu Dhabi as well, we have, as Paul have very briefly mentioned, we have an arbitration center as well, which is Abu Dhabi Arbitration and Conciliation and Mediation Center, or they call it ADCAC as well for commercial arbitration. And also all of those tools and vehicles, so to speak, will play a very big role in increasing the competition between the Emirates and kind of drive the wheel forward to promoting the UAE as a whole rather than Dubai only as a city, and taking the lead regionally and making it as arbitration friendly as possible. We have also seen since 2018 with the change of the federal legislation regarding arbitration, that there is a major shift locally with the adaptation of arbitration and mediation as well as tools for alternative dispute resolution, where the courts and local judicial systems are actually playing a very significant role in fortifying the position, again, not only to Dubai as a city, but to the UAE as a whole in the international arbitration scene. So yes, I think there is a very good chance and there is a very big opportunity for the Emirates, especially Abu Dhabi, to start kind of competing. And we have also Sharjah. They have a center called Tahkim. It's a local or a more domestic arbitration center, but they have like a very good set of rules that are modeled after the model law, and they're very efficient and extremely agile arbitration center. So all of these competitions coming from Abu Dhabi, coming from Sharjah to Dubai, I think will only result in a better environment for arbitration as a whole. And it might get some competition to Dubai, but I think ultimately it will only raise the profile for the UAE in the region as a leader in arbitration. And also notwithstanding the efforts that are happening in Saudi right now with SCCA.
Yeah, and when I was over in Dubai at the end of last year, everyone was talking about Saudi and their presentations at Arbitration Week. So it seems like they made a lot of noise then. So moving on from kind of this, what's going on in the Middle East, we're going to look at virtual hearings. So William, the arbitration community has been very quick to embrace virtual hearings. A number of the institutions have released protocols on how to hold them and best practice and so forth. Do we think this is a trend that's here to stay, or do we think we're all eager to get back to the old way of doing things?
Rachel, thank you. I'm absolutely convinced by the future of remote hearings. I've had a number of arbitrations this year from the Middle East to Montenegro, where parties have been on video. And what is very interesting is that initially, I think, including myself, people thought that there might be a real issue with the taking of evidence on a screen basis, particularly from people who perhaps didn't have English as their first language. But in actual fact, I think it actually can work. It works extremely well. It enables arbitrations to take place without the requirement for vast amounts of international travel. And where I think there's going to be a huge future in remote hearings is for arbitrations in parts of the world where it's very difficult to get arbitrators to travel to. And I think that there will be huge opportunities for arbitrators on the back of remote hearings. Are we going to have a hybrid? I think it's going to come down to choice. I think there will be arbitrations where, for whatever reason, the parties will want to travel and appear live. But certainly for procedural hearings, jurisdictional hearings, interim orders hearings, I see a move towards 100% remote hearings for these types of hearings before an arbitral tribunal. And I think that if there are going to be any in-person hearings in the future, it's likely to only be where there are witnesses. But I have experience in the last 12 months of arbitrations where we've taken a lot of witness evidence and it's worked extremely well. So I think I see this as an opportunity, and I know the courts want desperately to return to in-person hearings, but for international work, I think one of the upsides, if I can put it that way, of the pandemic is remote hearings, and that absolutely benefits the whole arbitration process, particularly on an international basis.
Fatima, do you agree? When we was talking before, you were saying you've come across such opposing views on this issue. What are your thoughts?
Actually, as we go and use, I would say, remote hearings more and more, you will see very polarizing views at the extreme ends of the argument, right? So there are of the view of yes, all the way, like similar to Williams, remote hearings are the future, and this is what we're going to do. And on the other side, you see the argument as well of this is denying parties their full rights to make their case and argue on behalf of their clients, especially when it comes to the issue of witness cross-examination, where it proves to have its limitations at point. Yes, it kind of worked out of necessity, I believe, but it doesn't always work. I believe that there needs to be a segregation of when remote hearings can and works amazingly for everybody, especially in smaller scale, less complex arbitrations, where there is no need for somebody to travel anywhere in order to kind of do a hearing for something that does not require massive dispositions or cross-examination and witness cross-examination, versus the cases that we need actually the face-to-face, and we need to kind of do the hot tubbing for the experts and the witness cross-examination. And there is the consideration to put as well that there are still some countries that do not have enough IT infrastructure to support online or virtual hearings, and these needs to be put under consideration. Yes, the future is developing, the technology is developing. I will not be shocked after a little while if, you know, the lie detector facial expression microchip is embedded within our virtual platforms, where we actually can use that technology to eliminate the issue of the doubts we have on cross-examination. But we also need to not forget about the countries where remote areas that truly the technology and the infrastructure does not support such technology, and therefore the parties will really be at a disadvantage. And we've all been through it, where, you know, half of the hearing time we're dealing with technical issues, you know, can you hear me? Or somebody who muted themselves out of mistake, or somebody who's in the room who should not be in the room, and so on.
Yeah. And Paul, do you have any strong views either way on this topic?
Yeah, I agree with both Fatima and William, and I think, you know, that pendulum is really swings around in terms of people's views, and what it's going to take is, dare I ask for it, a world where we get, say, 6 months with unrestricted travel, and pretty much, you know, the COVID-19 is somewhat in the background, to really start to get a feel for what people are actually going to settle into, sort of in the long term. At the moment, I think it's still too soon to tell because of everything that's going on and different jurisdictions and lockdown versus others aren't. So hopefully this year we'll start to get a clear picture on what the long term will look like.
And what about the other future trends in arbitration? What do we see as the biggest future trends in construction disputes?
For construction disputes, well, look, construction will remain a significant portion of international arbitration. I think around 25% of all international arbitration is construction based. That trend will continue, and there will be a lot, probably more arbitration over the next couple of years as we deal with some really sort of hot topics in construction, like the supply chain issues that the world is dealing with, both in terms of access to materials and pricing. And I pulled out an example. The Dow Jones Steel Index rose 100% from June 20 to June 21. You don't get that sort of change without it flowing into contracts. Somebody is either losing a lot of money, or there is a dispute over who's going to meet those increased costs. The COVID suite of issues, construction insolvency. If I take the UK example, we're seeing a huge increase in insolvency here, so we'll see more work required for emergency arbitration work in preventing calls on bonds, dealing with termination issues. So that will come in. And this whole virtual hybrid hearing debate will continue. But I think, and Fatima might well agree, I think one of the biggest trends in construction is going to be the use of non-determinative dispute resolution processes as the world, general counsel within big construction companies, etc., are pushed to find more cost-effective, faster ways to resolve disputes. So we are going to see, on the determinative side, I think probably an increased use in expert determination, as the perception is that it can speed up those determinative issues. But we're going to see a lot more facilitated negotiation with parties. We're going to see a lot more use of dispute avoidance boards or dispute adjudication boards. As an example, FIDIC, one of the biggest general use suite of construction contracts in the world, are very strong on that. The World Bank, who funds a lot of those sorts of projects, is very strong on the requirement for a standing dispute board to sit in the project and be very proactive in helping the parties avoid disputes, and then, if necessary, to adjudicate. So we will see a lot more of that coming into international construction disputes.
Thank you. And Fatima, what about you? What do you think of the trends? Do you think we're going to see more use of things like mediation and other forms of dispute resolution?
Yes, indeed. Mediation is definitely on the rise, especially in the wake of COVID, where at least from where I was standing at the time, when COVID hit, a lot of companies or disputing parties kind of took a pause at the arbitration proceeding, and some actually decided to settle, some kind of decided to take the route of arbitration in order to kind of filter or sift through the real issues, similar to what Paul have said, things that can be determined through an expert, they will be determined through an expert. Adjudication is a big part of the FEDIC contract, specifically when it comes to construction. They are fully supported in the UK by legislation, but here in the UAE, we don't have a legislation specific for adjudication. That being said, we see also an interest in the uptake of adjudication here in the UAE. People started inquiring about adjudicators, understanding if there's any, in order to kind of utilize it. And mediation, especially with the Singapore Convention and some countries in the Middle East, like Qatar, Saudi, who have joined as signatories, and now this convention is enforceable in those countries. There is a higher appetite to take mediation, if not just a way to kind of filter through the issues in order to close whatever smaller issues, and especially in bigger complex arbitrations in construction, and just focus the main conflict to specific points for arbitration. So yes, there is an appetite, there is a need, there are legislations that have been issued, that are being drafted in support of mediation. Almost all the arbitration centers in the UAE support mediation in one way, shape, or form. So I think it's only a matter of time before it becomes fully integrated within the construction field.
Thank you. And finally, before we take some questions from the audience, Paul, just very quickly, both you and William are members of Arbitra. And so do you want to tell us briefly what their role is in the arbitration process and what the link is between Arbitra and the IDRC?
Yes, definitely. And I've got to be very careful to get this right because the managing director is listening. So Arbitra is a set of full-time neutrals, so placed around the world, as far afield as Brisbane and Sydney in Australia. There would be New Zealand, but I'm here instead. And we are providing that the full sort of traditional, what you'd call ADR, alternative dispute resolution suite of services, from arbitration, adjudication, dispute boards, conflict boards, through into mediation and facilitated negotiation. So working on a global scale, because as claims increase around the world, and we see an increased use of dispute boards and these tools other than arbitration, early settlement, etc. Arbitra is there to provide that full suite of services and the appropriate neutrals around the world to assist parties. From my perspective as a member, what it provides for me is that infrastructure that I was used to at law firms, that I was used to as a barrister, so that William and I can focus on the dispute work and not the administrative side of it. Linked with the IDRC, nothing formal. We happen to have our offices buried in the centre of the IDRC, in the heartland of the hearings floor. So anybody who comes to an in-person hearing at the IDRC, when you arrive on the hearings floor, you can't help but see our office, and that's great because it allows the management team to deal with any drop-in questions and calls from people or parties or counsel who are having to be working here. So it's a perfect location in a fantastic new facility.
Thank you. So we've got a couple of questions that have come in, and I'll put those to the panel in a second. Just before I do, I just wanted to let you know about our next session, which is in about 2 weeks' time, a little bit earlier than we would normally have them. But that's because we'll be looking at MIPIN and how to make the most of your time there if you are attending. So if you're planning on heading to MIPIN, or you're unsure whether you should be, or want to know a little bit more about what happens when everyone decants for the week, do join us next week, and I'm sure one of my colleagues is going to put the link for you to sign up to that one in the chat box at some point before we end today. So if you want, or as always, visit limeslade.com/constructioncast. So our first question is about the charges. The charges at DIAC are much different from the DIFC. So if your contract refers to DIFC and now DIAC arbitration applies, what charges, I'm assuming they mean that they're asking about the costs there, I think. Fatima, do you want to take that one? Do you know the answer?
Well, what I know is, and again, I don't know what are the plans for the future, but I know what's being applied now. So if your case is ongoing and it have been ongoing since before September 2021, then the costs will be as per what have been agreed with DIFC-LCIA and DIAC separately, whichever is your institution. But if it's after September 2021, then definitely it will follow the cost model of DIAC, because it will be the rules of DIAC and the costs of DIAC are the ones that are going to govern the arbitration. Are those costs going to change? I'm not sure, to be honest. I don't know if it's under consideration or not. But you know, the message is, if it's ongoing, then things are as they are. If it's new, then it's DIAC. It's as simple as that.
Thank you. Next question is, do any of the panelists have any experience of successfully enforcing arbitral awards from different centres? Are there particular seats that are easier to enforce than others? Paul, do you want to?
Yes, and as I touched on, the approach of the courts to enforceability, both of agreements to arbitrate and arbitrate, is a sort of key consideration in choosing a seat. I don't think any of the main seats around the world, whether it be London, Singapore, Hong Kong, Dubai, etc., have any particular differences. Anybody who subscribes to the New York Convention, of which there are, I think, 156 plus countries, are by and large going to take the same approach to enforcement. So through the main centres, little difference, but it is one of the factors that parties should look at when deciding where they should do their work.
Thank you. And William, do you want to add anything on that question? You're on mute.
Annie, sorry, thank you very much. Yes, I would completely agree with Paul there.
Oh, you've muted yourself again. There we go. Oh, no.
I beg your pardon. Yes. So what I would say about choosing an arbitral seat, you really do have to think to yourself, if I have to enforce, which court do I want to enforce before, and which country has courts that are very pro-arbitration? Certainly, if you look at the UK, you're looking at one of the most progressive arbitration systems when it comes to enforcement in Europe, and other countries are following on suit. It's quite a lot for some countries to deal with the question of enforcement, but if you have clients who want to arbitrate, the first thing you should be thinking to yourself, what happens if we have to enforce? Can we? That's the multi-million-dollar question in any arbitration. Can we enforce? And I think that is probably a good point to end on. It's all ultimately, I'm afraid, about enforcement. So it is a key factor in the decision-making of where you're going to choose to arbitrate.
Brilliant. Thank you so much. And that is probably all we've got time for today. So all that's left is for me to thank our guests, Paul, William and Fatima, for joining me today. Thank you for giving up your time. And thank you to the IDRC for hosting us. As always, if you want any more information about the IDRC, any of the topics we've talked about today, or if you want to be put in touch with any of our speakers, just drop me a line, head over to the Limeslade website where all our contact details are, or stick something in the chat and we will get in touch with you and put you in touch with that. As always, this will be up on our YouTube channel. Head over there and subscribe to be notified of new videos. Sign up for the next one and hopefully we'll see you next month. Thank you very much.
Thank you all very much. Thank you, Annie. Thank you. Thank you for coming. Bye-bye.